for Surrey County Council against YXA and Wolverhampton City Council against YXA.
It might be helpful if I were to remind you, Ms Gumbel, that because Lord Fawkes finished 35 minutes early, you're due yourself to finish that much earlier than your anticipated time.
My Lord, yes, we've just been discussing that. I was anticipating that I would be finishing around 11:30.
Yeah.
I was going to begin by picking up some of the points from yesterday and before coming to the assumption of responsibility and reliance that I said last night would be my next topic. My Lord Stevens asked me yesterday in respect of some points in respect to the pleadings. Can I just point out the original pleadings, and I will go to that for a moment, because there I can pick up the point about the abuser. EF 193 is the original particulars of claim, and what happened was, because the Court of Appeal were looking at a reduced number of allegations that could amount to assumption of responsibility, we were asked to take out of the sequence of events as well all the points that didn't go to those pared down allegations. I would say it's actually quite helpful to have the whole sequence of events, because they do include the point my Lord Stevens was making in relation to the conviction of Mr. Austin, and we see that in the original pleading at EF 201 letter W, and that's where it was originally pleaded, and it was only crossed out because it didn't go to a specific assumption of responsibility allegation, but that's where we set out the conviction in relation to the 8-month-old baby and the cerebral hemorrhages. But then turning to the...
Schedule 1 of what Act?
I'm sorry, my Lord.
Austin was a Schedule 1 offender. A Schedule 1 of which Act? The Criminal Justice Act 2003 or which Act?
Yes, it's not the Sexual Offences Act. It's the Act. Yeah, can we just check that? I think it's the Schedule 1. The Sexual Offences Act is in relation to sexual offences, but there's the Act in relation to offences against children.
It's Children and Young Persons.
Children and Young Persons Act.
1933 or 1969.
Then the point we were being asked about survives the amended pleading, and that is at EF 159. And it's paragraph 28 at EF 178 is where we plead what would have happened in relation to the care order. I think that was the point we were being asked to identify. Paragraph 28 is EF 178, the middle of the page.
Because they would have discovered what facts?
Well, that relates back to the sequence of events that we set out.
Now all crossed out.
But what does survive is the basis of the duty of care at EF 1734, and 1734 is the assumption of responsibility, basis of the assumption of responsibility, and then in relation to the particulars of negligence at 179, the harm to the claimant was caused or contributed to and or permitted to take place, and the effects were worsened by reason of the negligence and or breach of the duties identified above of the defendants. And then it's the failing to commence care proceedings. It's recognised the claimant was suffering a risk of suffering significant harm attributable to the parenting, failing to carry out comprehensive assessment, and then separately pleaded at the bottom of EF 182, failing to undertake keeping safe work with the claimant in January 2000 or shortly thereafter, and that is separately pleading from the failure to commence care proceedings as a separate failure. And then the consequences of seeking a care order, we say, are set out at paragraph 28. I mean, the issues with the pleadings are the way that pleadings have evolved, certainly in many areas, including medical negligence, are that there is a long sequence of events pleaded in order that the whole background of where medical treatment is given, and we would say in terms of social services, the background is relevant and it's helpful to have it in the pleadings. It should be in a chronology attached rather than in the body of the pleadings, but certainly the practice appears to be, and it's that is how these cases are frequently pleaded. But we were asked to pare it down to only the events on which an assumption of responsibility could be based. The YXA pleading is at EF 666, and a point was raised by my Lord Stevens yesterday with my learned friend in relation to the extent of the concession made in relation to a duty owed whilst YXA was accommodated. And we do see the extent of the concession set out both in the judgments of Master Dagnall and of Mrs. Justice Stacey, and it's maybe relevant to see the terms of that concession as the judges thought it was made at EF 636. Is paragraph 90 of the judgment of Master Dagnall. It's probably better to begin at paragraph 89. The question is more complex as to whether a duty of care might exist where the defendant has provided respite care, and there was some issue about whether respite care was the right term, and that appears again in Mrs. Justice Stacey's judgment, but it's accommodated is the term we've been using. And that, as a result, becomes subject to the duty to safeguard and promote the claimant's welfare imposed by Section 22(3) of the 1989 Act. And then paragraph 90, with regard to this, it seems to me to have been common ground, and rightly so, that during the period the claimant was being provided with the respite care, the defendant owed some duty of care, and that this would extend to the mechanics of the return, e.g. the driving of the claimant back to his parents' house, of the claimant to the parents. Seems to me that that period or periods are clearly ones when the defendant had assumed a responsibility by positively receiving the claimant into their control, and that D&E's Berkshire analysis would apply in principle during those times. So it's said there that it was common ground. That was picked up again in the judgment of Mrs. Justice Stacey at paragraph 50. I think EF 151 is the better copy of her judgment. Yes, in paragraph 50, EF 151, paragraph 50, he noted there was no, and this is referring to Master Dagnall's judgment on the point, he noted that there was no dispute between the parties that a duty of care arose in relation to the defendant's performance of the functions of providing accommodation for the claimant and ancillary matters such as a transportation to and from the accommodation and education while accommodated, but the claimant was seeking to impose a duty of care to do something outside the performance of those functions, both in nature and temporally. But that, I'm only going to that for the extent of the concession, which is a duty of care owed whilst accommodated and whilst transporting back. And the footnote there relates to the, is it rightly called respite care, which I don't think is...
There seems to be a sort of rolling together within that concession, a duty of care not to injure, which doesn't on the face of it require an assumption of responsibility, and a duty of care to confer a benefit which does. Because talking about transportation to and from the accommodation, that's proving just to be a careful driver. I'm just not sure how focused the concession is, or maybe it was convenient for the judge just to deal with it in that abbreviated way.
My Lord, yes, I'm only going to it because my learned friend was asked about it, and it was taken from the case, the written case for this court, which didn't word for word reflect what was in the judgment. So we just thought it's relevant to see what the judges thought the concession was. But it is the starting point in relation to accommodation. If a duty of care is owed in any respect, it is outside the Barrett and Enfield line, if that's where the line is drawn. It is a concession that there can be an assumption of responsibility towards children for whom there is not a formal care order, which is the issue before this court. Where are we drawing the line? What is an example of an assumption of responsibility that comes within the N and Pool criteria? And it's...
So Master Dagnall is the clearer view, isn't it? He's taking the view as if it was interpreting the concession that there is an assumption of responsibility during the period that they're actually being accommodated. And then there's peripheral matters, getting the child back safely and things like that.
Yes, I mean, presumably that was just a response to the argument, well, where they go after being accommodated is a continuation of being accommodated, and it was conceded, or appears to have been thought to have been conceded as common ground, that the journey back would be, but not where you, in a sense, the mechanics of the journey back would be, but not the fact that you're leaving them in a place that isn't safe. Yeah. And that's the issue in YXA. I mean, that is the nub of the issue. Does it continue if you're accommodating? And ultimately, YXA was taken into care after being accommodated on he was initially accommodated on a short weekend type basis. He was then accommodated on a full-time basis, and then an application was made for a care order, is the sequence of events. And it's what is if you've assumed responsibility for him in that period, do you have to look at his welfare to the extent of whether he should be discharged or whether a care order should be applied for? That's the simple point in YXA.
But your point is that yesterday Lord Folkes didn't want to give us any examples of where there was an assumption of responsibility, whereas you say, well, there's already a concession made.
My Lord, yes.
To a limited degree.
My Lord, yes. It's and it fits.
There's no hint, is there, in the concession that the responsibility being undertaken during a period of respite care included a sort of responsibility to decide whether to make a care order?
But it's
responsibility for what is what I'm looking for.
Well, if there's a responsibility, if there's the point before, if the line is drawn at Barrett and Enfield, there is no assumption of responsibility and no duty of care owed to any child in child protection work other than those children for whom a care order has already been made, parental responsibility taken, and they become a different category. And the point that we're making is we have gone beyond that, and Enham Poole could have said Barrett and Enfield is the end of where you can where you have a duty of care towards children in child protection work. It didn't. It acknowledged that there could be an assumption of responsibility in that field, that D and East Berkshire wasn't wrongly decided, and what practitioners have been grappling with is what the questions that we've been asked in this court. What are the examples beyond Barrett and Enfield and up to CN and Poole where there wasn't an assumption of responsibility and there wasn't a duty of care owed, but there is a wide field in between? We say these are two examples which are strong examples of where there has been an assumption of responsibility, but that the position may be different in relation to the YXA case where there has been accommodation. And further, in answer to my Lord Borough's question as to whether there could be a difference between the YXA case and the HXA case, there could further be a difference in the HXA case between the offering of keeping safe work and it not being provided and the investigation into child abuse. So there's not necessarily the same answer for all of those issues. What the court is being asked to decide is, where is that line drawn? What are the examples? Because it's very, and that has, to be frank, that has been the difficulty with the pleadings, because assumption of responsibility after Enham Poole, certainly amongst practitioners, there wasn't clarity as to what needed to be pleaded and what would amount to an assumption of responsibility. Hence, all the possibilities being put in the pleadings, and in a sense, I don't apologise for that. They may not, be pleaded ideally, but what was sought was to raise all the possibilities because it wasn't known which would amount to an assumption of responsibility. And accommodating a child is perhaps the next obvious example after having a care order.
But your submission is still treating almost as a mantra the phrase assumption of responsibility, as if it's a single unified concept right across the board of these various different activities. For my part, I don't have any difficulty in thinking that if respite accommodation is offered by way of the conferral of a benefit on the child, and incidentally probably the parents as well, but on the child, then you may undertake a duty of care in the provision of that benefit. But that's something at one level completely different from the question whether you are incurring a common law duty of care and deciding whether to go the next stage and apply for a care order.
But it's difficult to see if you owe a duty of care to a child and the duty is to keep them safe, which would be the sort of the only shorthand way of describing what the duty would be, that keeping them safe doesn't involve not taking them somewhere where they're at risk. And one has to look at what's the difference between taking a child who is being accommodated on a trip out to a zoo with wild animals to taking the child back to the parents where you know they're abusers. Why is there a difference as to where you take them when they're being accommodated if you owe a duty to them while they're being accommodated?
So does that imply, because I think you're saying accommodating is the next step, I think you said,
yeah.
It would imply, would it not, that YXA are stronger facts than HXA?
In the trajectory of situations in which local authorities owe a duty of care, yes, because there they are looking after a child on a short-term basis as opposed to a long-term basis, and it can turn into it. And it's difficult to see why no duty would be owed to a child being accommodated when sometimes children are accommodated for years. I mean, there's been litigation in the family division about the length of time that children have been accommodated without a care order being applied for, and that being inappropriate. But it certainly happens that children are accommodated sometimes for years, and for the local authority to owe no duty to those children, but owe a duty of care to children where there is a formal care order, as in Barrett and Enfield, would seem anomalous.
The difficulty I think I have with that argument is that it's very clear that during the period of, well, I'll call it respite accommodation, the whole basis of the assumption of responsibility during that period is that the child will be returned. That is the basis on which the child is under the respite accommodation. Indeed, the parents have to consent to that. So it's hard to see that you then have an assumption of responsibility that extends beyond that, because it would contradict the basis on which the assumption of responsibility was given.
The other side of that is if you are accommodating a child with the parents' consent, if you find it's inappropriate for the child to go back to their parents from events that occur, I mean, some children being accommodated will make disclosures of specific sexual abuse, specifically say they're frightened to get, I'm taking extreme examples now, I'm not saying this is exactly what happened, because this child wasn't able to complain about things. It was the doctors who were complaining about his over-medication and things. But if you had a child who, whilst he was being accommodated, was making disclosures of abuse, then you would expect that the local authority, having a duty of care to him because he was being accommodated, would apply for a care order rather than send him home, which is in fact what happened in the end.
But we need an assumption of responsibility. And it's not clear to me that the assumption of responsibility, when you've taken or made the assumption of responsibility on a particular basis, can then be somehow extended.
Well, if the assumption of responsibility is the route to a duty of care, and duty of care by social services to a child must include a duty to keep the child reasonably safe from personal injury, then events that occur when you have a duty of care to that child, must inform what it's reasonable for you to do. It's very difficult to define what steps you can and can't take in terms of the point at which you assume responsibility. Assumption of responsibility being a route to a duty of care is simply the route into then owing a duty of care to that child. And you can't define in advance the constraints of it by looking at the circumstances in which the child came into accommodation. If you owe a duty to that child whilst they're in your accommodation, it must include a duty to keep them safe from personal injury. And if you are deliberately putting them somewhere where they're at risk of personal injury, I can't see any difficulty in that being a breach of your duty of care. But that will comes on to the breach aspect. But the assumption of responsibility is the route into owing a duty to that child in circumstances which there has been a gradual journey from Exham, Bedfordshire, and never having a duty from social services to children, to having a duty of care to children in your care. And we would say now to having a duty of care to children who are accommodated, and further in HXA to having a duty of care to children where you are looking into a specific child's complaints of being sexually abused in the home. But it is in that order, and that's why I took your lordships to the cases in that order yesterday to show the journey from no duty of care in any circumstances to a duty of care in some circumstances, and we're now looking at what are those circumstances beyond the one that is now well established, which is a child who is in the care of the local authority.
Well, if you... Section 20 is conveniently set out at page 61 in the Court of Appeal judgment. And I agree with my Lord Burrows that the whole basis of Section 20 ordinarily is that the child will be returned to the parents. There might be an exception, depending upon particular facts, because first of all, you have to have a child in need, and then under subsection 1C, there may have been a decision by the child protection authorities that the parents are permanently not, for whatever reason, prevented from providing him with suitable accommodation or care. So that is permanent prevention of providing care. So if there had been a resolution by the local authority that the parents were permanently unable to provide care, then there might be an assumption of responsibility not to return that child to those parents.
Well,
so that would depend upon particular facts, none of which are alleged in this case.
Well, eventually this child was in long-term accommodation, and that's when a care order was applied for.
Just concentrating on the pleadings in this case, there is no such allegation being made that there was a resolution that the parents were permanently incapable of providing suitable care.
Well, it is pleaded that he was received into long-term accommodation, and that then a care order was applied for.
But it's just chasing through the concessions, there is also the concession made by Lord Fawkes in the Court of Appeal, which is found at page 86, paragraph 84, subparagraph 3. It becomes a little bit more refined concession. But for my part, at present, I can see an assumption of responsibility for the safety of the child whilst accommodated, but I have difficulty in seeing an assumption of responsibility in relation to the return of the child.
I think that the difficulty is when you say there's assumption of responsibility which gives rise to a duty of care, what is the ambit of, we're on to what's the ambit of the duty of care? And we would say the duty of care must include a duty to keep the child reasonably safe from personal injury.
But the difficulty I have with that is that we have to pin this back to an assumption of responsibility. So we have to decide an assumption of responsibility to do what precisely. Now, you're phrasing it as, oh, well, there's an assumption of responsibility to keep the child safe. Now, that is actually very wide-ranging and, in a sense, I think has to be pinned down still further. Now, when you pin it down still further, it becomes an assumption of responsibility to take the child away from the parents. That's ultimately what your case is, that that's what they should have done. But it's hard to see that taking a child into respite care, that is, assuming responsibility for that period, can be equated to an assumption of responsibility to take the child away permanently, that is, to seek a care order. But it seems to me one further big step, and by saying, oh, there's an assumption of responsibility to keep the child safe, I understand why that helps, in a sense, your case, but I think it is too wide-ranging and vague. We need to pin it down as to what the precise assumption of responsibility is that you need to satisfy.
Well, it may help if I move on to the assumption of responsibility cases that we rely on, but what I would say is it is difficult that you would have to say in advance what that the assumption of responsibility was limited to particular facts, because what you do once you have a duty of care is going to depend on the events that evolve, and then it's going to be a matter of breach of duty and factual causation as to whether you do the right thing. All we're looking for with assumption of responsibility is a route to have a duty of care. That's only the first stage. The breach and the factual causation will be different issues to be determined once you've established there is a duty of care. Then are you in breach of it will depend on the facts that evolve once you have a duty of care. But you can't say in advance that only certain breaches will be actionable because the assumption of responsibility is limited in a particular way.
If I may express a concern that I have, you speak all the time, and I understand why, about duty of care, meaning duty of care in tort, but you sort of leave out of the overall picture that there's a whole range of statutory duties to which the local authority is subject. So it's not as though duty of care in tort is having to do all the work to secure protection for in fact, the primary work being done, so far as that's concerned, is in relation to the statutory duties. Whereas you seem to be saying, well, we've got to find an assumption of responsibility because that's the gateway to securing protection for the child. And I question that. The gateway to securing protection for the child are the statutory duties on the social workers and the local authority, as Paul and the other cases, Stephen and Wise and so on, made clear. In order to get to a common law duty of care sounding in damages, you need something more than that, more than just a general concern for the welfare of the child, which is what the statutory duty aims to secure.
But the statutory duty we're not suggesting is actionable. We're saying...
But that's the problem. But you're, and I understand why, trying to find an actionable, meaning actionable in damages, duty. But what I'm putting to you is that the law in this area isn't just made up of a duty which is actionable in damages. There are other duties as well. And it doesn't follow just because a child, in the general sense that Lord Burrows was referring to, needs to be protected from harm, that the whole work of that has to be done by an actionable duty of care sounding in damages. As I was putting to you, in fact, primarily it's done by the statutory duties, which don't sound in damages.
If I can add just a footnote of that, if Parliament has elected to impose these statutory duties and has also decided not to make them actionable, that's not a problem. That's the will of Parliament.
Indeed, and that takes takes one back full circle to Exon Bedfordshire, where Lord Brian Wilkinson set out that the statutory duties as one aspect, but there could also be a superimposed common law duty of care on the same facts, and the only reason there wasn't in Exon Bedfordshire was the policy reasons. But if those policy reasons weren't good, he wasn't saying there couldn't be a common law duty of care.
No, but Exon Bedfordshire, the retreat from Exon Bedfordshire only gets you so far. Exon Bedfordshire said there is a blanket rule that you can't have a common law duty of care sounding in damages. The courts have retreated from that. So, yes, in some circumstances, you can have a duty of care. The question is, in what circumstances? Indeed. And as the case law from Stone and Wise going through to Poole makes clear, it might be said, what you need to do is to point to things actively being done by the public authority, from which it can be said that if these things had been done by a private person, that would have involved them in assuming responsibility in the sense required in the law of tort that it gives leads on to a duty of care sounding in damages. And that's where the difficulty is, if I may say so, for you, that it's not enough to point to the retreat from Exon Bedfordshire. The law, it might be said, is now very clear that you need positively to be able to point to things which, if done by a private person, essentially, would have involved them in assuming a duty of care.
And of course, duties of care can exist without an assumption of responsibility.
Yeah.
When a social worker gives a child a lift, then there's a duty of care. That's not the result of an assumption of responsibility. It's the result of the application of ordinary principles of law of negligence.
And similarly, your example of putting them into a field full of wild animals. I mean, you don't need an assumption of responsibility for there to be a duty not to put a child into a field full of wild animals.
But the duty of care owed in Barrett and Enfield is an example of where there isn't an equivalent, because it's been said it's not the same as the duty of a parent. And so there are situations where, despite the Act only being done because of the statutory backdrop, there still is an established group of cases where there is a duty of care.
Well, in Barrett and Enfield, the effect of the care... Barrett and Enfield is another striking out case, so ultimately it's only deciding what is arguable. But it's a case concerned with the making of a care order, which has the effect of vesting parental responsibilities in the local authority. So, if you have parental responsibilities, then clearly you have a duty to protect the child from harm, which isn't confined to not harming it yourself, but, for example, making sure a young child doesn't wander into the road, into traffic.
But the issue here is it the same when you're only accommodating them? You haven't got a formal care order. Are you doing the same type of role in relation to them?
But surely the answer is no, you're not in the respite care situation for the reasons that Lord Burrows was putting to you. That the respite care, in this case at any rate, and I take the point that sometimes accommodation without a care order may drift so far across time that one would want to say, well, in substance it's care, and maybe the situation changes there. But the situation that we're dealing with is accommodation, temporary, short-term accommodation, occasional, all on the basis that the parents retain parental responsibility and the local authority is obliged, legally obliged, to give the child back to the parents at the end of each period of respite care. And yet you're trying to say that they, having accepted that role, that very limited role, somehow that encompasses an obligation also to apply for a care order, where those two duties, i.e. a legal duty to return the child to the parent and a duty to apply for a care order to remove parental responsibility, are in contradiction with each other, aren't they?
But if they, on the facts, don't think the child should be returned to the parents, as they didn't here, they apply for a care order, and that's exactly what they did do.
Right.
So the legal obligation to return the child to the parent is subject to them not applying for a care order, which overrides their obligation to return to the parent. So
if I may say so, that brings me back to the point that I was asking about previously, about whether a duty of care sounding in damages is doing the whole work of child protection here. It isn't, because we know that there are statutory obligations. So ordinarily, one might think that the duty on the local authority, if the child, for instance, while in respite care, starts mentioning matters of concern involving the parent, which might lead on further investigation to a concern about the safety of the child if returned to the parents. The primary way in which that sort of situation is dealt with is through the statutory obligation, which might itself carry through into a statutory obligation to apply for a care order. But that's all being done by the statutory, by the statute. You don't need a duty of care sounding in damages to secure legally those effects. You need something, but for a duty of care sounding in damages, you need something more than that.
But the original issue was, is it fair, just and reasonable, which we say we've gone beyond, that there should be a common law duty of care as well as the statutory duties. And there is, in the Barrett and Enfield situation, there are the statutory duties, but the House of Lords has found, it's at least arguable, there is also a common law duty of care, as well as the statutory duties that are there for looking after children in care. There's still the statutory duties in that.
But
sometimes.
Can I just... sorry.
Sorry, no, I finished.
How could... The test we're told we have to apply as a result of Poole and other cases is what sort of obligation would affect a private person in the same situation? And the private person here is either somebody privately offering respite as a neighbour, or some charity, in some kind of broad equivalent to the local authority, offering some sort of institutional respite in its home. Now, neither of those private persons could, under any stretch of common law imagination, have a duty to apply for a care order. So I have great difficulty in understanding how the common law parallel gets you to the duty which you say was broken in this case. The duty to apply for a care order can only be owed under statute by the local authority.
But the duties in relation to a child in care can only be applied by a local authority.
No, I'm talking about the child that's not in care. The critical process of getting them into care requires to apply for a care order, and unless I'm mistaken, that's not something the common law could impose upon a private individual.
But the duty, if the duty is to take care of the child to prevent injury, the mechanism by which the local authority can keep the child safe is ultimately applying for the care order.
Of course.
But the mechanism, a private individual looking after a child who they knew would be in severe danger if they sent them back home would also owe a duty to report that to the police or to do something rather than return a child to a known danger.
Yes, I see.
I can't see how someone looking after a child on a temporary basis could not be said to owe a duty not to put them in a dangerous situation, take them into a fire or into a situation with wild animals while they're looking after them, so that they would be owing a duty to that child for the period in which they were looking after them, not to cause personal injury. The fact that the way that they can address that is different. It is a feature of the fact that local authorities have duties that private individuals don't have, but that shouldn't go to whether they owe a duty of care while they're looking after the child. The non-local authority looking after a child who also has a duty to keep them safe would have the same type of duty, not to cause them injury. can I just turn then to the assumption of responsibility. The way we put the assumption of responsibility is that it can include the duty to take reasonable care to prevent harm or to effect a cure. That there's nothing controversial about the fact that in the context of assumption of responsibility, the duty should be to take care to prevent further harm or effect a cure. That's commonly, and that is caused by a third party. That is commonly the situation in relation to doctors and patients, that their duty is not to stop further harm in the treatment by treating with drugs if a patient has an infection, or to prevent further harm by an injury getting worse. So the idea that all where it's a third-party injury, there is a different analysis of where there's an assumption of responsibility, we say is actually not right, because third-party harm is often what professionals have to address. And where physical safety is involved, it's, we would say, not necessary to show conscious reliance. The case where that is discussed in some detail is a case that hasn't been looked at in these proceedings yet, which is Watson and British Boxing Board, which is EF 3115. It's tab 58 in the authorities bundle.
I'm so sorry, I missed the page number.
EF 3115.
Thank you very much.
Tab 58. Three 115 is the passage I'm going to. The Court of Appeal is a decision of the Court of Appeal, and I turn to it only for the discussion in relation to assumption of responsibility in the context of people who cannot be found to have relied. But the authority starts at 3099, and it deals with whether the British Board of Boxing should have had medical treatment available to boxers. But the passage that we would say is helpful in relation to analysing the assumption, responsibility and reliance aspect starts at paragraph 47 at the bottom of E3115. And it starts with the discussion in relation to a patient. It's clear on the authorities the duty to take reasonable care to prevent further harm and effect a cure is founded on the acceptance of the patient as a patient, which carries with it an implicit undertaking to care for the patient's needs. So on this basis, it's possible to draw a distinction between the doctor who goes to the assistance of the victim of a road traffic accident and the hospital that receives the victim into the casualty department. I do not consider that a conscious reliance by the patient on the hospital to exercise care is an essential element in the duty of care. The duty will be owed to the victim of a road accident who's received in the hospital unconscious. While it might be possible to rationalise the reason for the duty by postulating there's a general reliance by citizens upon the National Health Service to provide reasonable care, in the case of a medical emergency, English law has set its face against this line of reason. Seems to me the authorities support a principle that where A places himself in a relationship to B in which B's physical safety becomes dependent on the acts or omissions of A, A's conduct can suffice to impose on A duty to exercise reasonable care for B's safety. Such circumstances, A's conduct can accurately be described as the assumption of responsibility for B, whether responsibility is given its lay or legal meaning. Thus, it's been held the prison service owes a duty of care to take reasonable steps to prevent prisoners from committing suicide. That's, in one sense, an example of where there isn't an equivalent common law, equivalent non-statutory organisation with the same duties is the prison service. In Barrett and the Ministry of Defence, a naval rating drunk himself into a state of insensibility at the Royal Navy where he was serving, and then there was no duty in relation to stopping him drinking, but the court held that the Ministry of Defence had been under no duty of care to prevent the deceased from abusing alcohol to the extent that he did. Lord Justice Belden said, until he collapsed, I was told that the deceased was in law alone responsible for his condition. Thereafter, when the defendant assumed responsibility for him, it accepts that the measures taken fell short of the standard reasonably to be expected. It did not summon medical assistance, and its supervision of him was inadequate. And then there's a discussion of capital and counties. 53, these cases turn upon the assumption of responsibility to an individual. A number of authorities show that an acceptance of the role, usually under statutory powers or duties, of protecting the community in general from foreseeable dangers does not carry with it legal duty to safeguard the individual members of the community from those dangers. Thus, in capital and counties, Fire Brigade was under no common law duty to answer a call for help. On having done so, exercise reasonable skill and care to extinguish the fire. The police have been held to owe no duty to respond to a 999 call, or having done so, to exercise reasonable care to prevent a burglary, and that's the Alexandria case. These cases were distinguished in Kent and Griffiths. In the case, a doctor phoned for an ambulance to take to a hospital urgently a patient who'd suffered an asthma attack. The request for an ambulance was accepted. Arrival of the ambulance was greatly delayed without any reasonable explanation. And then there is a discussion in relation to Kent and Griffiths' case. Paragraph 55, as I read the judgment, the duty of care turned upon the acceptance by the ambulance service of the request to provide an ambulance, and thus the acceptance of responsibility for the care of a particular patient. And then at 57, this concludes my conclusion of cases dealing with the assumption of responsibility to exercise reasonable care to safeguard a victim from the consequences of an existing personal injury or illness. They support the proposition that the act of undertaking to, I think it must be to care for the medical needs of a victim of illness or injury will generally carry with it duty to exercise reasonable care in addressing those needs. While this may not be true of the volunteer who offers assistance at the scene of an accident, it will be true of a body whose purpose or includes the provision of such assistance. And what is helpful from that is the reference to the cases where there was unconscious reliance rather than conscious reliance, and that goes to the point I was making yesterday, that if there was an assumption of responsibility and reliance with an articulate young person, there must also be, it can't be essential to that there is conscious reliance, because assumption of responsibility can arise in situations where reliance is by definition unconscious because the patient is unconscious or too young to consciously rely. So it does describe the assumption of responsibility concept in the context of personal injury cases as not requiring the type of reliance that the economic loss cases require for, we would say, for obvious reasons. But it doesn't rule out there being an assumption of responsibility that there can't be conscious reliance. And yet, my own friend's written case and submissions are that there cannot be an assumption of responsibility unless there is active reliance. And that comes from the appellant's case at paragraph 62, EF 1004. Paragraph 62. There are cases where it's been held a public authority exercising statutory functions has assumed responsibility to a member of the public. In this respect, reliance is an essential ingredient. A public official may also be exercising a function which is equivalent to or analogous to service provided in the private sector, in respect of which it's well established a duty of care is owed. But what we say is that to say reliance is an essential ingredient cannot be stated that simply or be right in the context of children or people who are unconscious and cannot rely. That proposition is repeated in the appellant's summary. In paragraph 133 at EF 1040. Can I then just refer to the, in terms of reliance, I'm sorry, I'm coming close to 11:30. The other case we rely on in relation to reliance is the Privy Council case, Airport Authority and Western Air Limited, which is EF 1178. And this was a case from the Bahamas for the Privy Council in relation to not personal injury but property. It wasn't pure economic loss, it was a property case in terms of the safety of the aeroplane. And what was said at paragraph 44 on EF 1178, there is no difficulty, therefore, in bringing the circumstances within the first and third categories of case outlined by the appellant, whereby a defendant can be held liable to a claimant for harm caused by a third party. The appellant had created the risk of danger that the third party might cause harm to the claimant by reason of the defects in the system of security at the airport. Had it assumed a relevant responsibility towards the respondent by dint of being the sole agency which had the means to provide adequate protection for the aircraft. So the assumption, analysed in terms of assumption of responsibility, the reliance was by virtue of being the sole agency that would protect the aircraft. And then they go on to just, fair and reasonable. It was uniquely placed to provide the necessary protections. And we say there is some similarity here in terms of the reliance that the sole organisation or means by which these children could be protected was the protection of the local authority. Can I just then pick up, I've 2 points to pick up from cases referred to yesterday. The XY and Hounslow case that I know a friend took your lordships to, that was a case which in the end was decided by the Court of Appeal on the basis that the judge didn't approach the case as one of assumption of responsibility. But what is of some relevance is that it was pointed out that they weren't dealing with children in that situation. EF 1949 at paragraph 67 is where it's pointed out that this was really a case about the housing authority's duties, because the difficulty with the case was that the social worker was found, well, it was conceded that the social worker had acted entirely responsibly. It was the housing department where the fault had appeared, and the judge had treated them as one authority. That's paragraph 67 on 1949, but then at 1958, paragraphs 91 and 92 are the reasons why the Court of Appeal came to a different conclusion to the judge, because he didn't approach the matter as one of assumption of responsibility. And then at paragraph 92, we would make only these comments, apart from the general point made earlier that the judge did not consider whether the council assumed irrelevant responsibility. As to paragraph 199 and 120, in our judgment, there is an important difference between a case where the claimants are adults living in the community, albeit between a case where children assert that a duty of care is owed to them, and a case like this where the claimants are adults living in the community, albeit vulnerable adults. So I think that the decision in that case is not, we would say, helpful to the issues in this case, because it wasn't decided on an assumption of responsibility basis. And it was really a housing issue. In that sense, it was more similar to N and Poole, that what was really being asked was to be moving house. So there's just one passage in the Court of Appeal decision relating to the keeping safe work, and as to whether that, whether it would be right to consider that as a separate basis for assumption of responsibility in the YXA case. I can just go to EF 88. paragraphs 96 and 97. This is 96 and 97 is dealing with a point which the Court of Appeal found they differed from Mrs. Justice Lambert in DFX, and it's an important point in terms of who a duty is owed to when work is done to investigate the plight of a child. And Mrs. Justice Lambert had found that obtaining a report about a child was only for the purposes of the local authority, and that there couldn't be any duty owed to the child in relation to the content of that report. And he found that couldn't be right, that if the child is the subject of the investigation, there must be duties owed to the child in relation to the content of that. And we would say that is supported by the analysis in Phelps, where the report of the educational psychologist, again, it was said it was obtained only for the purposes of the education authority, and found that that can't be right. If the child is the subject of the report, there must be duties owed to the child too. And that's at EF 1677. At the bottom of the page, letter H, when carrying out the assessment and advising the education authority, did the psychologist owe a duty of care to the child? The psychologist, I confess I entertain no doubt on how that question should be answered. The educational psychologist was professionally qualified, brought in by the education authority to assist it in carrying out its educational functions. Purpose of his assessment was enable him to give expert advice to the education authority about the child. The authority was to act on the advice in deciding what course to adopt in the best interest of the pupil with a learning difficulty. Throughout, the child was very dependent upon the expert's assessment. The child was in a singularly vulnerable position. Child's parents will seldom be in a position to know what the psychologist's advice was sound or not. Seems to me on fact an example par excellence, the situation where the law will regard the professional as owing a duty of care to a third party as well as to his own employer. The duty on the pupil would march hand in hand with the professional's responsibilities to his. And although this is a slightly different situation because we're looking at the responsibility of the educational psychologist, it is the same point that was made in DFX, that if a local authority gets a report about children, and in that case it was whether the child would be safe left with her father, and the report said not when she gets to adolescence, that there was no duty owed to the child in relation to dealing with that report. That does seem rather inconsistent with the idea that the duty to the child must go hand in hand with that to the authority for whom the report is written. Sorry, I'm going past the time. Is there anything else? Yes, I'm just being reminded that my own friend suggested that the law has been fixed and since N Pools, so that judges other than the Court of Appeal in this case have not found it difficult to interpret where there's been an assumption of responsibility. And we would just point out that in the case of J, which was a Court of Appeal decision relating to whether a defendant could retract admissions of liability in relation to a child who had not been removed from their mother. The defendant had made admissions, and the case proceeded on that basis until the decision in Enham Pool, when the defendant sought to withdraw the admission, and the judge at first instance said that the admission could be withdrawn because Enham Pool had changed the landscape. The Court of Appeal said that that was not clear and that there were still issues. It's at EF 2442 is where that authority is.
Ms. Gumble, you appreciate your...
Yeah, I'm sorry, this is the last point I made.
You will need to come to a close quite soon.
Well, perhaps I can just give that reference, but it is an example of a case where the Court of Appeal did not think that the position was clear following Enham Pool, and the passage is at paragraph 41 on page EF 2455 to 2456. So we would say that although Master Dagnall and Deputy Master Baggett and Mrs. Justice Stacey thought that the position was now clear, the Court of Appeal in that case didn't think the position was clear, and we are still struggling with where an assumption of responsibility can be established. By going to trial to do so, we would rely on the fact that Lord Justice Baker wasn't suggesting every case is going to have to go to trial, but that a series of cases will establish where there is an assumption of responsibility, and it's only when there's been a series of cases looking at where there can be an assumption of responsibility will the position settle down, so that cases will be settled because they'll come within that ambit or won't. And at the moment, there are a huge number of strikeout claims because to certainly practitioners it isn't clear where there is an assumption of responsibility.
Sorry, I'm just looking at this authority. It doesn't seem to say that there's any uncertainty arising out of Enham Pool, does it?
Well,
they seem to say that facts weren't pleaded on the basis of which it was said that there had been an assumption of responsibility, but Lord Justice Lewison says, page 2456, that's hardly surprising since both the duty and the breach of duty were admitted before the proceedings began. There is no need to do so. I'm not sure what you're trying to get out of this authority.
The point was that the judge who heard the application had said it would be unarguable that there was an assumption of responsibility on facts where a child hadn't been removed from care, because since Enham Pool, those cases would all fail, and the Court of Appeal said, no, that's not the case.
All right.
It isn't clear that all those cases will fail.
Yes, thank you.
And that was the only point, that it wasn't as clear as the judge at first instance thought that the cases based on assumption of responsibility were bound to fail, which is what the Masters and Mrs. Justice Stacey in this case had found.
Obviously we haven't looked at this until now, but it's a case to do with a child actually in care, is it?
No, it's a failure to remove a child at a very young age from its mother, and the defendants had admitted breach of duty in failing to remove, but after Enham Pool said we shouldn't have admitted responsibility, we want to withdraw the admission, and the judge who heard the case said, yes, you can withdraw the admission because it's going to be unarguable after Enham Pool that you owed a duty of care. And the Court of Appeal said, no, it isn't unarguable. We don't know what the facts are. We've got to look at them. But it's not simply unarguable after Enham Pool that there would be an assumption of responsibility in relation to the duty to remove a child from its home. I'm sorry that I've overrun from my 11:30. But those are the submissions on behalf of.
Thank you very much, Ms. Gumbel. Any thoughts?
My Lords, my learned friend began her submissions by saying that we had not referred to the facts of these cases in our submissions. They are, of course, recorded in all the judgments, and we do deal with them in our written case. And specifically, we deal with the allegations, as we apprehend them to be, at 1032 and 1033 and following, and 1034, dealing specifically with failing to carry out keeping safe work, failing to commence care proceedings, and failing to carry out investigations and assessments. I won't read out those passages, but that's our response to that submission. I drew the court's attention to the fact that allegations in this type of case tend to be contained in pleadings with voluminous detail on the basis that something might be regarded as an assumption of responsibility. Now, my learned friend began with what has been described as a paradigm example of a 14-year-old going to social services complaining of sex abuse by a stepfather, told by the social worker, we'll make sure you're moved, and then does nothing, resulting in further abuse. I think that's a fair summary. And she said that would be a clear case of assumption of responsibility. Her argument proceeds because there is then reliance, which creates an assumption of responsibility. She then says, but there cannot only be an assumption of responsibility if there is reliance like this. What about the disabled, mentally ill claimant who cannot complain? My friend says, obviously, that doesn't need reliance, but there would be some sort of implied promise on the part of the social service. Duty cannot depend, she says, on the ability to complain. I think that's a fair summary of what she said. And I'll come shortly as to why we submit, even those extreme facts, and of course, good advocacy, you take the extreme facts in order to illustrate the potency of your argument. As to why we say, even in those circumstances, there's no assumption of responsibility. And after giving those two examples, her argument in our submission began to unravel. Seeking legal advice and resolving to keep safe work amounts apparently to an assumption of responsibility, and so does accommodating temporarily a child under Section 20, not where there was anything wrong with the accommodation. The criticism is of a return, at all times with the consent of the parents, who remained at all times with full parental rights. So the Section 20 accommodation does not alter the essential allegation, which is of a failure to confer a benefit, i.e. by taking steps which would have stopped the abuse. Ultimately, the argument seemed to boil down to be once a local authority does anything, then there is an assumption of responsibility, or at least arguably an assumption of responsibility. So presumably, if the local authority is unobservant, incompetent, short-staffed, or whatever, and does not know of any abuse or any other matter that needs investigation, there is no assumption of responsibility. In terms of responding to complaints, in Michael, there was, of course, the failure to respond to a 999 call. There was no duty held in that case. And in Smith, which is part of the Van Colley decision, the criticism was of a failure to respond to a series of complaints which failed to prevent murder. No duty in those circumstances. My learned friend, given the exigency of time, wholly understandably, somewhat glossed over the facts of Kent and Griffiths, which was able, in the Court of Appeal's view, for there to be an assumption of responsibility because there was a specific request and an assurance that an ambulance would shortly be on its way, thereby meaning that the alternative, which is driving the asthmatic patient to the hospital, was not deployed. But generally speaking, we say if an ambulance takes longer to arrive at someone's house having been called, then one would hope there is no duty. Just as there was no duty, as explained in Capital and Counties, in respect of the fire brigade, if the fire brigade takes a very long time to arrive at fire or gets lost in the lanes. The further problem with my learned friend's argument is that it fails to take into account that there is ordinarily no duty on the part of public or private defendants to protect against the acts of third parties. The width of her submissions, which would involve assumptions of responsibility in potentially almost every aspect of social work, would cut across this now well-established principle. Similarly, these cases involve failure to confirm a benefit, or omissions as they were used to be known. The law is equally clear that no duty is owed in these circumstances. How is that consistent with assumptions of responsibility in all the circumstances of these cases? A postulation of an assumption of responsibility means that the exception can devour the rule. My Lords, I said I would not refer to Stovin and Wise or Gorringe, but in view of the failure by my learned friend to address the difficulties that she encounters with Stovin, I fear I must briefly refer to that case, and indeed briefly to Gorringe. The case is at 1733. The plaintiff was riding a motorcycle, was seriously injured. It was at a junction which was not a busy one. It was known by the county council as the highway authority to be dangerous because road users' view was restricted by a bank or an adjoining land. After a site meeting, the council actually accepted a recommendation provided by the owner of the land, agreed to improve the visibility, but it wasn't actually done. And the plaintiff's claim was that they were negligent and in breach of statutory duty in not making the change and not making it less dangerous. In the course of the judgment of Lord Hoffman for the majority, he discussed at 1763 the concept of particular and general reliance. Just above letter F on that page. In Sutherlandshire Council and Hayman, Brennan J., as I mentioned, thought that a statutory power could never generate a common law duty of care unless the public authority had created an expectation that the power would be used and the plaintiff had suffered damage from reliance on that expectation. A common example is the Lighthouse Authority, which by the exercise of its power to build and maintain a lighthouse creates in mariners an expectation that the light will warn them of danger. In such circumstances, he owes a duty of care which requires it not to extinguish the light without giving reasonable notice. This form of liability based on representation and reliance does not depend upon the public nature of the authority's powers and causes no problem. In the same case, however, Mason J. suggested a different basis on which public powers might rise to a duty of care, and then he quotes what he says. And then letter C over the page, 1764, the ground for imposing a duty of care has been called general reliance. It has little in common with the ordinary doctrine of reliance. The plaintiff does not need to have relied upon the expectation that the power be used, or even know that it existed. It appears rather to refer to general expectations in the community, which the individual plaintiff may or may not have shared. A widespread assumption that a statutory power will be exercised may affect the general pattern of economic and social behaviour. For example, insurance premiums may take into account the expectation that statutory powers of inspection or accident prevention will ordinarily prevent certain kinds of risk from materialise. Thus, the doctrine of general reliance requires an inquiry into the role of a given statutory power in the behaviour of members of the general public. It then refers to ands, and going down the page just above letter G, but the fact that it would be irrational not to exercise the power is, I have said, only one of the conditions which has to be satisfied. It also is necessary to discern a policy which confers a right to financial compensation if the power has not been exercised. Mason J. thought that in Sutherlandshire that such a policy might be inferred if the power was intended to protect members of the public from risks against which they could not guard themselves. In Invercargill, found it general patterns of social behaviour. I don't propose to explore further the doctrine of general reliance because, for reasons which I'll explain, I think there are no grounds upon which the present case can be brought within it. I will only note in passing that its application may require some very careful analysis of the role which the expected exercise of the statutory power plays in community behaviour. For example, in one case it's true that the fire brigade is there to protect people in situations in which they cannot be expected to protect themselves. On the other hand, they can and do protect themselves by insurance against the risk of fire. It's not obvious that there should be a right to compensation from a negligent fire authority, which will ordinarily inure by right of subrogation to an insurance company. The only reason would be to provide a general deterrent against inefficiency, but there must be better ways of doing this than by compensating insurance companies out of public funds, etc. And this line of authority was then taken up in Gorringe, which is at 1353. This was a case we see at 1353. The claimant, driving on a country road, reached a point with a sharp crest in the road followed by a curb, and seeing a bus, she braked, car skidded, hit the bus and was severely injured. And some years prior to the accident, there had been a slow sign painted on the road, but it had subsequently disappeared. And the argument was that it should have been put back. And the appeal partly concerned the construction of Section 41(1) of the Highways Act, but it also made some useful comments about the interrelationship between statutory duties and the existence of some duty of care. And can I take the court to 1363? He considered the Court of Appeal's judgment, but at paragraph 32 of his judgment, he said this: speaking for myself, I find it difficult to imagine a case in which a common law duty can be founded simply upon the failure, however irrational, to provide some benefit which a public authority has power to provide. For example, the majority reason in Stoven and Wise was applied in capital and counties to fire authorities, which have a general public law duty to make provision for efficient firefighting. The Court of Appeal held, in my view, correctly that this did not create a common law duty. And Stuart Smith, LJ, giving the judgment of the Court of Appeal, said in our judgment, and this is really a better way of putting what I said earlier in relation to the fire brigade. Those two cases, and I've obviously been selective, and there are other passages of use, were of course a considerable part of the analysis in N and Poole. And as I read the way the authorities have gone, although many of the observations in X and Bedfordshire might represent good, sound common sense, the approach now is to look at a particular potential duty or assumption of responsibility through the prism of Stoven and Wise and Gorringe to determine whether there is a duty or an assumption of responsibility. In Poole, this court said that the policy considerations no longer, I paraphrase, chimed with a modern approach to deciding on the existence of a duty. I pose the rhetorical question, is policy wholly irrelevant in the task that the courts perform? Lord Manson in Michael was reluctant to accept that it played no part. But what part it plays, if the court reads Lord Brown-Wilkinson's policy reasons for not superimposing a duty of care, they do provide a pretty good reason as to why there might be, on the old-fashioned analysis, it would not be fair, just, and reasonable to impose a duty. But they also illuminate the task that any judge might have in deciding whether or not there is a breach.
If I can interrupt, I don't think we should overestimate the extent to which there has been a change in the substance of what's going on, because first of all, in a novel situation, it's accepted in Robinson that one does apply a fair, just and reasonable analysis. And it's also made clear in Robinson and Poole that the legislative scheme may be inconsistent with the imposition of a duty of care. And obviously one would have regard to the sort of considerations that Lord Brown-Wilkinson cited in Bedfordshire in deciding whether that was the position.
Precisely so, my lord. And in fact, he was at pains, quite apart from the policy analysis, he was at pains to say that normally, where there is no claim for breach of statutory duty, we would not be superimposing a common law duty, because, of course, Parliament is perfectly capable of making a statute give rise to a private law action, and does quite often. And the reasons that he gives for under policy are relevant, we submit, to the analysis even performed through the Stovin and Wise type approach. And also in mitigation, it might be said that even consistent with Poole and Robinson, this was, and Melinda Friend's submission was, this was a novel case that he was considering. In X and Bedfordshire, there was no real authority on the matter, so that the sort of exercise which I think the court, with respect, rightly said should not be performed in every single case. In some cases, it will be necessary to go to the root of the matter and find out what the constituent elements are. So we submit that the way now to analyse these cases is that a statutory power does not generally generate a duty of care, and a failure to do something or to investigate further, even if you acknowledge that it needs to be done, as was the case in Stovin and Gorringe, does not mean there is a duty of care. And Melinda Friend's submissions entirely fails to take this principle into account in either her written or oral submissions. And in effect, her submissions can only be really right if Poole was wrongly decided, and that is not the respondent's case. In essence, what she is saying is that I may lose on the swings of duty of care, but I can bring my claims home on the roundabout of assumption of responsibility. And there is a conflation in many of her submissions between a duty of care and assumption of responsibility. And as I said, I'd come back to the paradigm case. Of course, and understandably, she takes such a case where we would very much expect the social services to intervene and be very disappointed if they did not do so, just as we would expect the Northern Ireland social services to intervene to protect an abandoned child. But the facts of these cases are rarely straightforward. If a claimant says, I complained to social services, this may be unrecorded in social services records, or it may even be disputed. If the relevant social worker can be found many years later or can remember anything about the case, or the social worker may have reason to doubt the veracity or reliability of the complainant. Is it enough, and it seems to be on Learned Friend's case, for a claimant to plead in her particulars of claim, I told the social about what had happened? And therefore there is potentially an acknowledgement of an assumption of responsibility. I am instructed that there have been a number of recent letters before action in which reliance or assumption of responsibility is based on the basis that there was a phone call which was unanswered or not acted upon by the duty social worker. So that contacting to complain in an extreme case, which Learned Friend postulates, arouses one's natural feeling, well, the social worker should do something. But we respectfully submit that the court should be very careful by saying that there's some sort of concept of notice which gives rise to an assumption of responsibility. And this brings me back to how judges are to approach these cases at trial. And if the Court of Appeal are right, all of them will go to trial unless they compromise. They will have to go through often long and probably imperfect records, discursive particulars of claim. Learned Friend didn't resile from the fact that it's helpful, whether it's in an appendix or as part of the pleading to set out the whole particulars of claim, and will be invited to, as it were, trawl through pleadings and social services, having regard to the whole story, and to identify a particular juncture at which there was an assumption of responsibility. The Poole case in our submission raises precisely the same issues of non-intervention by social workers as arise in both these cases. The headnote makes it clear that this was not a housing case any more than the case of X and Y was a housing case. They were considering both those cases whether or not the social workers should have exercised the powers that they had to intervene and protect the individuals from harm. My Lords, it's our submission that to succeed in this case, we simply have to satisfy the court that these particular allegations, those that remain in this case, do not arguably amount to an assumption of responsibility, because, as Mrs. Justice Stacey concluded, there is not something more. But it may be helpful in dealing with the difference between being in care and not being in care if I take the court to a case called Williams, which you have not yet seen. This is at 3195. So the head note, claimant's parents, which is at 31. Sorry, slight technical hitch. What's the page here? 3139 is the head note. The claimant's parents' 12-year-old son was caught shoplifting, and he told the police he had no money for lunch. His father hit him with a belt. The police visited the family home and, finding it to be unhygienic and dangerous state unfit for habitation by children, used their powers under Section 46 to remove all 8 of the parents' children who were placed with foster care. As I pause there to say, of course, the police have certain powers too. The parents were arrested but released on bail on condition that neither should have unsupervised contact with any of the children. They signed a safeguarding agreement, document prepared by the local authority, by which they agreed that all children would remain in their foster placements for the present time. The agreement did not specify the basis on which the local authority were purporting to act, but it was later accepted that it was under the provisions of Section 20 of the 1989 Act. And that's the element of the case that I'd like to emphasise. And if we could go to 3195, paragraphs 42. Yes, perhaps earlier on, the Baroness Hale is discussing removing a child from the care of a parent is very different from stepping into the breach when a parent is not looking after the child. But at 42, fifthly, subsection 7 operates as a restriction on the powers and duties of the local authority under subsections 1 to 5. The authority cannot accommodate a child if a parent with parental responsibility who is willing and able either to accommodate the child herself or to arrange someone else to do so objects to the local authority doing so. It says nothing about the suitability of the parent or of the accommodation which the parent wishes to arrange. Refers to what Lady Justice Black said. And then she quotes Lady Justice Black, who emphasises the fact that there has to be consent. I agree. The words interpolated by amendment in subsection 7 serve a different purpose. Thus, for example, a father who is separated from the mother is not offering the child a home or offering to arrange an alternative, cannot object to the local authority accommodating the child at the mother's request. In Medway Council and M, claimants were compulsorily detained in hospital could not object to the local authority accommodating the child unless they were able to arrange alternative accommodation. That is all subject to Section 7 does. It means a local authority have neither the power nor the duty to accommodate the child if a parent with parental responsibility proposes to accommodate the child herself or to arrange for someone else to do so. If the local authority. This is an important sentence. If the local authority consider the proposed arrangements not merely unsuitable, but likely to cause the child significant harm, they should apply for an emergency protection order. Sixthly, subsection 8 makes it absolutely clear that a parent with parental responsibility may remove the child from accommodation, provided or arranged by a local authority at any time. There is no need to give notice in writing or otherwise. The only caveat pointed out by Mr. Justice Mumby, as he then was in G.R. versus Nottingham Council, is that the right of anyone to take necessary steps to protect a person, including a child, from being physically harmed by another. For example, if a parent turned up drunk demanding to drive the child home. In such circumstances, the people caring for the child would have the power under Section 3.5 of the 89 Act to do what is reasonable in all the circumstances for the purpose of safeguarding or promoting the child's welfare. Lords, that's quite a helpful distinction that is being made between the relatively limited powers that the local authority has and why we submit they should not generate or would not generate an assumption of responsibility. When a child is in care, we know that there is the decision of Barrett and Enfield. When a child is in care, there will generally be a care plan for that child. And while control of the child may not be the right word, there will probably be greater physical proximity. And of course, the local authority will have powers that can be exercised, which would not be the case if the child was under parental control. Organising medical treatment, arranging fostering and the like. So it is understandable why the House of Lords did not strike out the claim in Barrett. And I made my submissions about that case. The role of the European Court of Human Rights was a factor and contributed to the reluctance to strike out. It was also a decision reached where policy was still part of the analysis and was before Stovin and Wise and Gorringe. And what is important is that the decision said nothing about the scope of any duty. We were not asking, however, the court to overrule the decision, but we simply submit that it did not decide anything which might help determine whether or not there was an assumption of responsibility in cases where a child is not in care. Lord, during her submissions this morning, the learned friend suggested that the assumption of responsibility, as it were, derived from the Section 20 accommodation, as I understood it, because it then followed that there was a duty, which on the basis there wasn't, to investigate and go through all the processes leading to a care order. But our submission is to say that the Section 20 doesn't change the whole picture. It's part and parcel of what the social services do and what I described in opening as a range of tools that they have, tools which are mostly designed to prevent the possibility of a child being taken into care, which is very much the last resort. But in effect, this morning, the learned friend's submission came down to this, that there was a duty to take reasonable care, to take care for the personal safety of a claimant, foreseeably affected. That, in a sense, reverses X, ignores Poole, ignores Stovin and Wise and Gorringe, and also conflates the concept of duty with assumption of responsibility. As I understand assumption of responsibility, it is because the court has deemed in the circumstances there to be an assumption of responsibility that there will then be a duty. It first has to decide that on the particular facts there is an assumption of responsibility. And our submission has always been that in the context of exercising statutory powers and where there is a complex statutory scheme involving many agencies, the court should be very slow to extract from a sequence of events some particular act or omission which constitutes an assumption of responsibility, which, as it were, outflanks the general rule where there will be no duty of care. My learned friend relied on the Airport Authority case, and that, insofar as it was of assistance to the court, was based on the fact that the Airport Authority was the sole body involved. That I understood to be the point that was being extracted from the case. Of course, it isn't actually the case that the analogy really works, because social services are one of the agencies which we would expect to intervene. It may be the police, it may be doctors. So it's not, that particular case doesn't help, we submit, on the analysis that we have to perform. The learned friend also returned to her argument that social workers were professionals, and said there was really no difference between the educational psychologist and a doctor and a social worker. Our answer to that, and forgive me if I repeat myself, is that really that analogy doesn't work, because it is quite clear that the NHS is by way of background, whereby a doctor owes a duty to the patient in an ordinary way, and it was decided that the educational psychologist who sees the individual, assesses them, is more like a doctor-patient than the social services, I submit, which was described, or could be described as a regulatory agency, but it is certainly not a professional, classic professional relationship owed by a doctor or any other professional. My Lords, our submission is that the law after Poole and Michael and Robinson was sufficiently clear that it could be applied by the lower courts. View of two masters, Mrs. Justice Stacey and Mrs. Justice Lambert. On the other hand, we say, the Court of Appeal's decision is a recipe for uncertainty and expense. The majority of these cases are so-called failure to remove cases. As well as all the other problems, a court trying these cases will have to determine whether or not a child would in fact have been taken into care as a result of a possibly contested court proceedings. As I have submitted, and the guidance makes entirely clear, it is a high threshold that has to be crossed before a child is taken into care. And the trend in social work at the moment seems to be very much against that, but helping the family manage as best they can, in no doubt far from ideal circumstances, rather than taking the child away. And Lords, we rightly expect our public authorities to do their job, very often one, as in this case, defined by Parliament. In the case of social workers, we expect them to take responsibility, as the statute provides, for children within the relevant area. But it does not mean that this translates into there being an actionable duty of care, whether called a duty of care in negligence or an assumption of responsibility. There may, of course, be some circumstances, hard to envisage, where there has been an assumption of responsibility, and there will always be Donoghue and Stevenson type normal neighbour duties would exist in a wide variety of circumstances, would exist whether the body was a public body or a private person. But in the vast majority of these cases, often very sad cases, it should not result in a claimant suing a social worker, whether on the basis of a duty of care or an assumption of responsibility. My Lords, those are our submissions.
Thank you very much, Lord Fawkes. Well, we are grateful to Council for their submissions. We will take time to consider them, and we'll let you have our judgment in due course. The Court will adjourn.